Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking, your go-to YouTube channel for insightful discussions on all things legal. I'm Melanie Fanade, a licensed paralegal that's passionate about unraveling the complexities of the law for you. So in today's episode, we are diving into a fundamental aspect of the lawyer-client relationship, confidentiality. And joining me is Phil Stiles, a seasoned legal counsel with a deep understanding on how confidentiality shapes interactions between lawyers and their clients. We'll explore what confidentiality means in a legal context, its importance, and how it influences trust and communication between legal professionals and those they represent. Paul, what does attorney-client privilege entail, and how does it protect the confidentiality of communications between a lawyer and their client?
Well, attorney-client privilege arises when there is any private communication between a lawyer and their client. And it's important to understand that the attorney-client relationship starts in advance of any retainer. So if somebody is giving advice or even doing some initial intake in their capacity as a lawyer, all of that is subject to solicitor-client privilege. And solicitor-client privilege is an important concept for individuals to understand who are hiring a lawyer, because it's implicit that it will exist so long as the communication is private, and it should be made explicit when that privilege is waived or is no longer in existence. So, for example, if there is another person present in the room, I, as the lawyer, would be unable to guarantee solicitor-client privilege because I cannot make guarantees for what the third party or the other person in the room who is not a client will do with the information. So solicitor-client privilege arises from the first contact with the lawyer, and it goes on long after a case is finished. I, as a lawyer, am obligated to keep all details of the case completely confidential. It's indefinite. There's no end to it. Only with the client's explicit permission can I divulge certain details. And as we'll discuss later, in the context of any dispute that comes up between the client and the lawyer, when, for example, the Law Society gets involved and there's a complaint. And even then, it's only in very narrow circumstances, if there is a safety issue regarding the individual, so a client, or somebody else, and the confidentiality or privilege of the information can only be relaxed to the extent that I'm able to prevent a tragedy and no further. So in other words, because you've told me, for example, and this is a hypothetical, that you're going to harm someone at the courthouse tomorrow, I can divulge only enough to prevent that from happening and not get into the details of your case with anybody. It's not that the floodgates are open, it's just that there's a few drops allowed through to give me a chance to ensure the public is safe. And that's all.
So, Phil, what information is typically covered under the solicitor-client privilege?
So information that's covered has essentially everything between the lawyer and the client, even casual communication. Now, you're not supposed to communicate sensitive information by way of text message if you're a lawyer. Solicitor-client privilege is inclusive of even the innocuous chit-chat that happens between you and the client. A lot of people don't know this. It even has to do with the identity of the client. So a lawyer should not in any way divulge to anybody the fact that one particular individual is their client. It goes that far. So what does it include? It includes emails, it includes phone calls, it includes any document that is sent specifically to the lawyer from the client or vice versa. Solicitor-client privilege includes any of the lawyer's notes, any of the client's notes based on what the lawyer said. And that privilege is upheld right from the beginning of a police investigation. Police should not be asking about what somebody said to their lawyer or vice versa. Right into the court and through the entire process, a Crown cannot cross-examine an accused on what their lawyer told them or what they learned from their lawyer. It's strictly solicitor-client privileged information.
Are the support personnel in the lawyer's office also covered under the solicitor-client privilege?
Yes, staff at a firm sign what's called a confidentiality agreement, and the staff at a firm are duty bound to keep everything confidential that they become privy to that has to do with communication between the client and the lawyer, or any information that both parties are sharing with each other, any conversation. Staff members at a firm are bound by solicitor-client privilege and confidentiality.
Well, thank you so much, Paul, for joining us today and for helping us understand the client solicitor privilege. And thank you to everyone else for joining us on the Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.